You know, around maybe a dozen years ago, I heard something that absolutely changed my life and changed my practice. One of my mentors said to me that smart business people in the design and construction industry are asking, why do we pay our lawyers so much money to prepare for trials that never occur? And if you've been involved in construction litigation, it was probably your experience that you made some mistake, you get swept along in a process, and the lawyers litigate for a year or two, and then the case settles on the courthouse steps, which sort of gets at the bigger point that why would we put so much time and effort and be willing to go through so much trouble on the back end when there's a better way? There's a better way to do this. The way you do it is you put more thought and attention on the front end, which is why I agree with the last presentation very much. And I went ahead and left the big law world. I started my own firm 6 years ago for purposes that have a lot to do with the title of this presentation: Leverage Opportunity and Risk in Construction Projects. And my thesis here today is that regardless of who you are, if you don't have a lot of bargaining power and you don't have the ability to negotiate contract terms, that doesn't mean that you have to have your eyes closed to risk. And that doesn't mean that you can be powerless to affect the outcome on your projects. It's about having a system and having a thoughtful process. I have some QR codes in here because I've never given a speech less than 90 minutes, so I'm going to be really pressed to get this all in. My bio's there. Probably the most interesting thing that you'll find are pictures of my kids and my dogs. But I've been a lawyer in Chicago and nationally in the construction space for 25 years. I don't do anything else. I don't do real estate law. I only help people build buildings. It's been 6 years since I started my firm. And my whole reason for being a lawyer is that litigation is nothing other than the least efficient means of exchanging information that mankind has devised. It should be avoided at all costs. I think everybody can agree with that. But the question is, how do you go about doing it? And so that's what I want to try to bring here today, is just a little different approach for being proactive and thinking about what we can do. I'm going to go ahead and start with a question. What is the golden rule in construction? And I'm curious to see if anybody wants to take a guess other than my associate Levi over there, who knows the answer to this question. Anybody want to venture a guess what the golden rule is in construction? Levi?
Whoever has the gold makes the rules.
That's right. And that's why I like representing owners and developers, because when I do, I get to structure the contracts and the project delivery systems from the top down. I get to work with people like Jose and Alera to make sure there's sensible insurance terms, and generally things go right. But it's my guess that many people in the room here are not at the top of the contract chain. You might be at the bottom. And so I could give an academic sermon about how contracts should be that would fall flat immediately, because the reality is that a lot of people in the room may have the ability to ask for one change or two changes. It might not be universally true. There might be general contractors in the room that have even more bargaining power. But the reality is that we have to take whatever bargaining power you have and make the most of it. But if you have no ability to affect your contract terms at all, that doesn't mean that you have to have your eyes closed to risk. If you are in the construction industry, you probably work first and you get paid later. And I'm going to do a top 5 countdown here. We're going to start with 5, 4, 3, 2, 1 in terms of things that I think are important things for you to think about. And the first thing that I want you to think about is that you're a credit manager. If you work first and you get paid later, you're extending credit, whether you realize it or not. I bet a lot of people in this room have been through the underwriting process for bonds. They're going to look at your financials. They're going to make sure it's worthwhile to extend the risk. If you have not gone through that underwriting process, you probably have bought a home or a car. You can remember what the bank puts you through before they're going to give you a loan. So if you are going to work first and get paid second, it's important for you to think about which projects and which clients are most creditworthy. And this is, even if you don't have the ability to affect the contract terms, you could, if you have access to Google, you can do some basic Googling and you can get to property records and you can understand who owns the property. Is there a mortgage on the property? If I have to make a mechanics lien claim, is it the sort of thing that's likely to have value, or is it likely to have no value? If you scan the QR code, it would take you to a page on our website where we have a menu that you can sort by who you are, a design builder, architect, engineer, contractor. There's 370 individual pages that tell stories about real projects, real contract situation that we've handled for different people in the industry. My website's got over 500 pages. It's got over 130 videos. If you have a question about construction, you could probably find the answer by going to the search bar. But when you think like a credit manager, what you're going to do is you're going to say, okay, I got to keep my people busy. I got to keep my equipment busy. That means I can't be too picky. I don't have the ability to negotiate a lot of contracts. So what can I do? I would suggest that maybe you score each project on a scale of 1 to 5. 1 being the least risky kind of project, 5 being the most risky kind of project. You know, for 1, you know, you go online, you figure out who owns the property, you realize that the contractor you're working for has got a contract with that entity. It's not a single purpose LLC that's a piece of paper that has no assets. The general contractor who you work for is well known to you, someone that has a history of paying you. You know, and there's a lot more that you can look at too. Is it a public project? Is it a private project? Are there bonds? You could think about what the payment risk is. On the other end, a tier 5 project might be one where you know, you're working for a design builder that's a single purpose LLC. It's a piece of paper. It has no assets. That's working for someone who's trying to buy the property that doesn't own the property, so you might not have any mechanics lien rights. It's not a public project, so there's no bonds, and you have, you know, essentially no reason to think that you would be paid. There'd be no incentive for them to not stiff you. And if it's a tier 5 project and you're thinking about getting involved in it, what do? Maybe you'll walk if you can't get the one edit that you need in the contract. But if you decide that you want to take on a tier 5 project because you absolutely have to and you can't affect the contract, you know what you might want to do? Don't let your account receivable run out more than 60 days. You know, a lot of times people come to me and they say, I have this problem. I've been, you know, I'm 6 months unpaid. And it's like, well, there's very little that I can do for you because, you know, you took a big risk that could have been avoided even if you can't negotiate the contracts. Again, sticking with the payment issue because money is the lifeblood for contractors. If you work first and you get paid later, what can you do in order to make sure that you are not on the losing end? You can understand what your contracts say about deadlines for making various kinds of claims, for giving various kinds of notice. And, you know, as somebody who does a lot of mechanics lien work, both for contractors but also for owners and developers, let me answer a question for you right now. A lot of people think, oh my God, if I send a lien notice, people are going to look down on me. They're going to think I'm messing up their job. Maybe I shouldn't do it. I don't think that that's true at all. If I represent the owner and I see a subcontractor that's asking for smart edits to their contract that are within reason, and they send me a lien notice, I have respect for that contractor because there's no business person in their right mind that would sleep on deadlines in the contract, in the law, for liens, for bonds, because why would you ever take a risk of non-payment? And in this day and age of ChatGPT, it's easier than ever. Just feed your contract into ChatGPT, ask it to tell you what the deadlines are, and then, you know, once a month when you sit down with your CFO or your controller, your office manager, whoever does your invoicing, you look at your accounts receivable, you say, okay, I'm getting paid on all the projects I expected, and then there's 3 or 4 that are getting late. I got a tier 2 project that, you know, I'm late payment on, no problem, we're gonna let it run. Tier 5 project, don't know the people, can't affect the contract, not getting paid. Maybe that's when you pull out that sheet of paper ChatGPT prepared for you and you said, you know, maybe I need to put a notice out there. And I can tell you, as someone who represents a lot of people at the top of the heap contractually, as well as those at the bottom of the heap, when I see a contractor that is enforcing their lien rights, I do not think down on them. I think that they're smart business people, and I'm more inclined to have them on my next project because I assume that that thoughtful approach probably carries through to everything they do for the work that they do in addition to their approach for contracts. If you scan that QR code, it'll take you to what I think is the most comprehensive mechanics lien page in Illinois in terms of making a claim, defending a claim, how you should think about it. And let me also tell you that mechanics liens are not just pieces of paper. They're not just blanks to fill in. They are enormously complicated. If you took all of the case law in Illinois that has ever been written on mechanics liens and you printed it out, assuming each case was 10 pages long, it'd be a 33.5-story tall building. Mechanics liens are complicated. I've never met a mechanics lien that I can't defeat as an owner. So if you're thinking about doing a lien claim, don't come to your lawyer the day before your deadline. Notice that it's a risky project after you've not been paid, maybe for a month or two. Give the lawyer a month to try to help you out. Don't come at the last minute, because it's not just a form that you fill out. It's something that takes a lot of thought and attention if you don't want to have it get defeated. So, assuming people in the audience lack leverage, you got to keep your people busy. You got to keep your equipment busy. You can't be too picky about the jobs that you take on. You don't want to not take the project. You can't affect the contract terms, and so you don't have a lot of leverage, but you don't want to blow everything sky high. You don't want to pour gasoline on the upstream parties and light them on fire by terminating your contract or walking away from the contract. What do you do? Well, there's a lot of things that you can do, but something I think that is particularly important is to understand your right to temporarily stop working. That's not a nuclear option. If you walk off the project and you terminate, you may find yourself in a world of hurt, and you may find yourself facing all kinds of claims that go well beyond your non-payment. The right to suspend your work is extremely powerful, and I'm not going to suggest to you that it's the most important thing that subcontractors and trade contractors in the lower tiers need to try to get into their contracts, because I think it'd be irresponsible for me to give legal advice without knowing about the project and your situation. But boy, oh boy, that is a good thing to have in your contract, and it's worth understanding. Even if you don't have the right to suspend your work under your contract, there is an Illinois statute that gives you that right under certain circumstances. So again, when you are thinking about risk and you're thinking about tiers of risk, different kinds of projects, how long you let your account receivable run out, know that there's a law out there that might allow you to say, hey, GC, I love you, hugs and kisses, can't wait to come back on the project in a week. We're gonna take a time out for a week because we haven't been paid. It's worth understanding what your rights are. It's like the last presentation. It's worth having a system. Don't go into a project like this just because you got to keep your people busy and your equipment busy, just because you got to work, just because you can't affect the contract terms necessarily. That doesn't mean you got to go like this, wind up in a lawsuit, have lawyers get involved, lose control of everything, 2 or 3 years of litigation, you waste a lot of money, and then the case settles anyway. I mean, there's a better way, and it involves shifting more thought and attention to the front end. This is not rocket science. Anybody with access to Google that wants to understand some of the basic things that you want to look for in a project could easily score a project between a 1 to 5 tier risk. If you were to scan that QR code, you'd see one of the 370 pages on my website that tells a story, and this is a story of how we use suspension to get one of our clients paid. This is the thing that I think people who aren't lawyers may not understand more than anything. A lot of times I'll get a potential client that will reach out to me and they'll say, I've been defrauded, I need justice. And what you gotta understand is that the arbitrators and the judges that resolve business disputes like design and construction disputes, they don't worship at the altar of justice, they worship at the altar of predictability. The judges don't have the ability to write, new terms into your contract, and they're not going to read the invisible ink in your contract any more than a cop can pull you over for blowing through an invisible stop sign. The judges and the arbitrators that resolve business disputes like design and construction disputes are going to read literally what your contract says. I unfortunately have an arbitration in Delaware right now because my client in Illinois decided that they're going to have a dispute resolution clause that says that we're going to have our arbitrations in Delaware. So off to Delaware I go. Generally, whoever follows the contract closest wins. So what is the best thing that you can do if you want to avoid risk? I think it's to have a good contract. Realistically, some of you may never have the ability to have fantastic contracts because, whoever has the gold makes the rules. And a lot of people who play in this industry have no gold. And literally, this is a discussion in my office. When I'm working with Levi and other lawyers, we talk about how much gold various people have because we can't push too far. If I push too far on behalf of my client, they get thrown off the project, I lose a client. So we have to be very sensitive about what we're really talking about here. If you scan that QR code, you will see an article that I wrote in 2009 that is entitled, "Is It Worth Pursuing Your Design and Construction Claim?" And I think that everyone who is unpaid, anyone who thinks they have a claim, read that article, because it's going to make a lot of points that I think people don't think about. I am fond of telling people that, particularly in the Circuit Court of Cook County, where if you bring a lawsuit, you may be 5 years older by the time that it resolves, and I've heard, I don't know this for sure, but I've heard people say that the average jury in Cook County has a 7th grade education. So 5 years from now, you're going to go and talk to a jury that is going to be bored within 60 seconds of the start of the trial. They're going to be put out for being there. They're going to be on their phone. Is that the best investment? Because if you're really going to pour money into a claim, what you're talking about is making an investment. And I'm fond of saying that, no, I mean, you should put your money in the S&P 500 and give it 5 years to appreciate. I mean, so you got to think of yourself as a credit manager. You got to think about, if you're going to make a claim, is it a smart investment? If you go to that QR code, you will see an article that will kind of give you things that you should think about before you'd even think about making a claim, including, probably the number one thing. What does your contract say? Because when new clients contact me and they want me to, advance a fraud claim for them, I'm kind of like, I don't really know that this is, the kind of thing I want to get involved in. It's 1 in 1,000 people that say they've been defrauded that were actually defrauded. And now we're going to get to number 1 in our countdown of things that you should think about if you want to avoid a situation where you wind up in a stupid lawsuit and you lose control and you burn your hard-earned relationships in the industry and you wind up having to talk to a lawyer about giving them documents and sitting in depositions and doing all the things that are poison for your business. If you want to avoid risk, and if you are not just playing to play, but playing to win, what's the number one thing that I think that you should do? You got to consult your insurance advisor a lot more than you are. I mean, guys like Jose, guys like Steve, they're not just here for renewal time. These guys are your essential partners. And if some of you are thinking that I've saved, the number one thing for a seminar where I'm sitting with an insurance, advisor group that, if you're about to accuse me of being a kiss ass, I'll just say in my own defense, it wouldn't be the first time I've been accused of that. And so, but if you go to that QR code, you will see a video that I recorded 6 years ago. So I'm not just saying this now. There is a video that is 6 years old where I make the essential point that being an insurance broker in the state of Illinois and every other state, it's a licensed and regulated profession. I am not an insurance broker. I do not have that licensure. There's a good reason. There's education. There's continuing education. I work with my clients' insurance advisors on every one of their contracts, because when I look at a contract and it's like, how are these insurance terms? I'm like, well, I have no idea what your insurance program is. So unless we get your broker involved, you may breach the contract the instant you lift the pen off the page from signing it, unless we find out whether you have the insurance that you need to comply with the contract. But not just that. You have to understand whether you have enough insurance to meet your own needs. It's not just the upstream party's demands. What are your needs as a business? And you want to know who understands your operations. Do you have subsidiaries? What's your financial position? What kind of insurance program for you? It's not me. I'm the lawyer. That's the reason why I never, well, 1% of the time would I get involved in a project or a contract without talking to my clients' brokers. It is exceptionally important, and I am not in the business of telling my clients to not sign contracts, even if they're very risky, but I will say that generally the only time that I would ever warn people off signing a contract is if there is a glaring problem with the insurance program, because the owner's insurance covers certain things and the contractor's insurance covers certain things, and there are carve-outs that are filled with subcontractors' insurance, and there are going out of business level risks, going to find a new job level risks when your business goes down in flames. If the insurance isn't just right, I know enough to be dangerous. I can facilitate the conversation. I can get in with your broker. We can get into an email. But I can't do this alone. You gotta talk to Jose, gotta talk to Steve, gotta talk to whomever. You gotta talk to them more than just at renewal time. And this isn't a situation where it's like, whoever gets their broker, they hang on to them, and everybody else go find your other brokers. You should, if you're a general contractor, you should want your subcontractors to talk to Jose and Steve as well. And if you're a general contractor, you better hope that your owner is insured through Alera as well, because when everybody is singing off the same sheet of music, what you have is a very well insured project where insurable risks are covered, and that is really what we're looking for here. Because I am lucky enough to be in this room, I have put together this final QR code. If you scan this, you will go to a Contact Us page on the website where if people wish to get in touch with us in the future, if you fill out this Contact Us page, I'll know that you come through Alera. And of course, we give all of our clients lots of great service. But I in particular, will be able to tell if you're an Alera person. And so I don't do business cards anymore. If you're going to, scan any QR code, this is the most important one. Bookmark it. If you ever, need to chat about something, I promise I won't grab you by your feet and shake you upside down until all the money falls out of your pocket. We're here to help the Alera.
How much will you allow us to drop out of our pockets? You said not all of it.
I don't think I could lift many of you by your ankles and shake you anyway. So, I'm happy. I'm always happy to make more friends in the construction industry. And then there's the disclaimer because I'm a lawyer, blah, 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 blah. Thank you very much for the opportunity to be here today.